Thank you for joining us for 3Bs on the Law podcast, hosted by Trisha Barita, Camille Canali, and Susan Dawson. Disclaimer, this podcast is for entertainment and informational purposes only, not meant to provide legal advice, and does not create an attorney-client relationship. Also, remember, laws change or they differ by jurisdiction, so this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you.
Hi, everybody, and welcome to another episode of 3Bs on the Law. Today, we actually are going to talk about the new OSHA Emergency Temporary Rule that was put in place that surrounds President Biden's executive order requiring companies with 100 or more employees to either mandate the vaccine or have their employees tested. It's been a long-awaited rule, and of course, as soon as the rule came out, there was legal action taken by several states and districts. And so, Trisha, what's kind of the current status of the new OSHA rule?
Well, it's on pause right now. The Fifth Circuit on Saturday, right after, because the rule was published in the Federal Register on November 5th, and then it didn't take long for all the states to then file against with several different actions. So there's actually multiple states. Multiple attorney generals got involved across the United States, filing in their own various circuits, and some of them claiming that the rule was unconstitutional, some of them claiming arguments about OSHA overstepping and, going too far with their emergency temporary standard powers, because this is certainly unprecedented to see them do something in this way. And so anyway, the Fifth Circuit, on Saturday, which is the circuit above Texas that I'm in, they went ahead and stayed. They put a temporary stay, and then they asked for some briefing from the U.S. government and some briefing on all the parties that brought the stay, which was actually private individuals and private businesses and state representatives bringing that action. So that briefing is being done, and there will be more rulings to come. And then there are other circuits that have also come forward and done the same. I think up to over 26 states have all gotten involved with opposing this for various different reasons. So we knew that it was going to be contentious, but I have to say, guys, this is probably the most contentious I've ever seen anything like this, where all the states are fighting about whether or not the federal government has the power to do this. So it's super, super geeky law, fascinating. Maybe not all for our listeners, but I'm all in.
Right. I'm not going to lie, Trisha, I picked on you because I knew Texas led the charge.
Well, there's some people here that are very fired up about this, as most of the U.S., as you can see, one way or another, people have some thoughts about this one.
Right. And so I'm so sorry, Susan. Go ahead.
No, I was just going to agree that from a purely lawyer geek perspective, it's fascinating to watch how this rolls out. But from an employer perspective, as I'm also an employer, wow, there's a lot going on right now. Not quite as fun.
Yeah. And it's very stressful because you're like, am I going to have to do this? Am I not going to have to do this? And so I know we're kind of telling people to be ready, which is why we decided to go ahead and release this podcast, because we at least wanted people to know kind of the broad overview of what they need to do.
Right.
And that evaluation. And I think that starts with who needs to comply.
The first question is, do you have 100 employees or not? Right. If you quite clearly do not in any way, shape, or form, counting employees, have 100, great. But if you are one of those companies that has that question, do I include part-timers? Do I include remote workers? There's a lot of questions. And the general answer is you count everyone on the payroll. Doesn't matter where they're located, how many hours they work. Do they work in the office or out? So remote workers qualify, part-time workers qualify. If you've got, let's say you've got 50 in office in every state, and in every state there's 2 employees, that's still 100. Okay, so you're going to count regardless of how they're working or where they're working. So some of the more complicated comes in, what about seasonal workers? Well, if you go over the 100 mark with your payroll, then you have 100 employees. So there might be some industries that there's going to be a change if you have seasonal workforce. There's other questions we're not going to get into as much detail here, but if you're a franchise, there's a different way. There might be depending on your company, it might be a different way to look at that. So a lot of franchise owners own more than one location. Also, there's what using a staffing company. So there's more in-depth questions there that you really need to talk to your attorney and get more information on, and those. But generally, from your general business, you count everybody on the payroll, and if you can get to 100 up, you're in.
And once you're in, even if you go below 100. So just keep that in mind moving forward.
Right. So then once you're in. So now what? Right? What's the next step, Camille?
Well, you got to decide if you're going to mandate the vaccine or you're going to leave it up to the employees to get the vaccine. But those who opt not to, you got to do the testing. And so I know, Tricia, that has been kind of the big debate amongst employers is what are they going to do?
Yeah, I think you have to make a decision before you get too far into this about which path you're going to go on. But I think you can't make that decision without doing maybe some research. The first place you should research is what are your local laws anyway, because if they already have some, enforcement about vaccines in your local jurisdictions, then, you may be leaning one way or the other, right? So the laws here in Texas are different in California. And so certainly what industry you're in, if you're in the healthcare industry, there's other restrictions outside of this rule that we're talking about here today. Or if you're a federal contractor, you'll need to be following those. But if you're just looking at the rule with the OSHA ETS rule here today, you need to have an understanding that this testing requirement we're going to talk about in a minute is pretty complicated. And you need to figure out how it's going to work administratively with you if you're going to go that route to give the employees the option to either get vaccinated or do the testing. And if you don't go that route, then the only other option on the table is the mandatory vaccine according to this ETS rule. And so I think my suggestion is start doing some research on what the local laws are if you're not familiar, and how they're playing into all of this, because there's been some changes since this is all coming out. And then also having an understanding of what does testing mean, really understanding that, and what does mandatory vaccine mean, and the differences between doing the testing optional or vaccine route versus mandatory vaccine. And then the other big thing I would research, if I was an employer, is how many people in the company are already vaccinated, because that may sway you one way or another. If you have an entirely, unvaccinated workforce right now, you may not want to go the mandatory vaccine route because, you may lose workers. People may not decide, they don't want to go forward with this. I've seen that quite a bit here in Texas with some employers that have gone the mandatory vaccine route. Employees have just decided, I'm not working for you. And right now we all know there's a workforce shortage. So that's something to take into consideration, as well as if you have a large part of your workforce that's already vaccinated, again, that may sway you the other way. So that's my thoughts on that. What do you think, ladies?
Yeah, I think if you haven't already started gathering those vaccination cards of your employees and documenting the percentages of who's vaccinated and who's not, get to it. It's good information to have, and you're required to do it anyway under this law. And so, having that information is power, I think, because it can help you make a decision. You may be surprised and it turns out 2 of your 200 employees aren't vaccinated. I mean, if that's the case, then why are you going to go through all of the steps to set up getting employees tested? Because even if in California, you have to pay for the testing. I know in other states, it's not mandated by this rule, but it still costs attorney time and productivity, to have people tested. And so it's a big thing to figure out.
Yeah. And please don't have a big assembly. Remember and say, hey, who's vaccinated? Who's not? Raise your hand. Remember, it's all confidential. I've heard some pretty interesting stories about employers, deciding to issue wristbands and all kinds of things that I think I would definitely shy away from, because remember, this information is still considered confidential medical information about whether they got tested or not, got vaccinated or not.
I think that's a very interesting point, Tricia, because under this order, employees who are not vaccinated are required to mask. And so
I know,
unless the employer is going to mandate everyone wearing masks, which is required here in Los Angeles anyway, when you're indoors, people are going to know who's vaccinated and who's not anyway. And so I thought that was a very interesting part of this law, because I think it does in an indirect way disclose exactly who's vaccinated and who's not in most locations where masking is not mandatory, like in Los Angeles.
Yeah. And my take on that is, because I've seen that now with some of the state and local, guidance where they've done that sort of, hey, you need to have the individuals that aren't, and a lot of it came, of course, where do we know all that came from? Of course, it all came out of the CDC, when the CDC said, if you're not vaccinated, you got to wear a mask. So everyone that's vaccinated doesn't have to wear a mask. And then of course we won't even go down that route, but they waffled on all of that later. But but when that all came out, that's kind of where everybody went. And I kind of agree with you. Yeah, I think that's kind of what's probably the basis of what was running some of this stuff that came out in the OSHA ETS. But I still say, right, even though that's the rule, I still say management just has to remember that it's still considered confidential. So if they openly disclose it, even though they've asked them to wear the mask, you're still running into that confidentiality issue, because you got the EOC right there going, you got to protect that information, and you got to put it in a separate file, and it's medical information. So, and we've known that this whole time. So it's still all these government agencies sort of running up against each other. But good point, Kamal.
Yeah. And then I think once you determine, and that's a huge decision, quite frankly, for a lot of companies, is, are you going to mandate it or are you not? I know we've talked about it in my office kind of off and on, whether we're going to mandate it or not. We're not at 100 employees, obviously, so it's not mandatory for us. But if you are not going to mandate it, you got to set up this testing. And it sounds, I think, easier than it is, because to me, this sounds like it could be a logistical nightmare.
Right. Lots of questions related to how you're going to set up this testing that companies are going to have to figure out, that they're not getting a lot of guidance on.
I think if you can get organized, you can get it done. I just think you need to be very organized. Because
I agree.
There's a way to do this testing and not be. I always thought the testing was going to be kind of crazy anyway, just because we've seen in the different states testing results coming back at random times. So depending on, I think as the states go in and out of issues with the availability of tests and how fast you can get the tests back and all of that plays into, now where we're going to see a whole bunch of maybe employers going down this testing route if this ETS rule holds, because they don't want to do the mandatory vaccine. And then you've got more stress on the testing laboratory community, right? And that may change how fast you can get these results back and what all that means. But I think there's a way to organize it. But I do think it is you're going to have to be Johnny on the spot on knowing who is administering all this and who's keeping track of all these different moving parts of who needs to get tested and who's keeping track of the records for that. Right, Camille?
Yeah. There's all these record keeping obligations. And though I think at this juncture, it's good, even if you're not currently testing unvaccinated or vaccinated employees for that matter, it's good to at least have a plan in place that you can implement should this come into effect, because we don't know when the ruling is going to come down as to whether or not this new OSHA rule and the executive order can move forward. And there's deadlines. I know December 5th, I think, is a big deadline for getting a lot of this done in the OSHA rule. And so, you want to be ready just in case at this juncture.
Yep.
Yeah. The December deadline, if the rule comes out of its stay somehow in the middle of all this mess, that December ruling is talking a little bit about the preparing yourself for the issue related to the mask requirements if they're going to be unvaccinated. So that's the kind of tricky part. The testing issue, that goes to January 4th. So a lot of people may be looking at this going, well, I'll just kind of hold, because they'll figure this out by January 4th for sure, right? But if for some reason that the stay gets overturned and it does go into effect, you have this December 5th rule. And that's running off 30 days from when it was published in the Federal Register. So it was published November 5th. So 30 days from then, technically, is when it's supposed to be going into effect as it relates to unvaccinated workers have to wear masks. That's what it says, basically. So that part still was never going to be in effect in January. It was always going to be December 5th, 30 days after the rule.
Right. But you also need to have all of your policies in place. Even though you don't have to start the testing, your policies, at least under this rule, the way I read it, your policies for all of this need to be in effect by December 5th. I read it that you need to have those policies in place within 30 days. And obviously that's stayed at the moment, but if it's lifted the Wednesday before Thanksgiving, how many lawyers do you think are going to want to work over Thanksgiving updating policies? So everybody's ready to go by December 5th. And so I think you want to be thinking about these and what you actually want your policies to be and what you want them to look like, so that even if you don't have policies, you're ready to go with those types of decisions.
Right, especially given the hefty fines that are in the standard rule, right? The $13,653 for each violation, and it can go up significantly from there depending on a variety of factors. So keeping in mind, OSHA is putting some hefty fines here. So it's time to make sure you're ready.
Yeah, and I don't know about you ladies, but when OSHA has visited a client of mine, I have never seen a client walk away with the minimum OSHA fine.
Yeah, well, OSHA, that's the interesting thing about OSHA is, so and there's a big fuss, right? Everyone's all fussing about, does OSHA have the power to do this? And OSHA, the reality of it is, if you really understand OSHA, is they don't have a lot of enforcement people. So if they come out to enforce something against you, you're in a lot of hot water. They're going to find some stuff, and they're going to take some some green dollar bills home, because they did not waste their time to come tootle out to see you and to just give you a sort of oh, you really need to fix a few things here. I mean, they're serious if they've gone that far. And so, yeah. And the thing is that, and Camille's absolutely right. And as Susan is too, we could see something happen here. The stay is lifted the day before December 5th. You're not ready. You don't have any policies and you're scrambling, or you're like, hey, whatever. And an employee reports you on December 5th that you're in violation, and you could have one of these fines against you. So we're not trying to totally scare you, but we're trying to say this is pretty serious, one way or another. So I think you have to take your gamble as to how you're going to handle it. But lawyers are always if they're requiring a written policy, wouldn't you rather be ready if something happens here and it goes into effect versus being stuck trying to figure out how to put the policy together at the last minute, and it may not make all the meet all the marks, because this is no joke, a tricky set of guidelines that they've given the employers here. This isn't simple by any means. And so I think you're going to need to make sure that you have that written policy and have all the different pieces in it working right. And you need to have all the compliance issues that you're ready to sort of administer with all the employees, and your management needs to be on board and understand how all this works too. So I think training is going to be a big piece to go along with those policies as well. So
you got it. And, we've been talking here for almost 20 minutes now, and we haven't even touched the surface of all of the regulations that need compliance with it. It's a very complicated, it's 490 pages long rule. And, it's going to take a while for everybody to get in compliance with it. So
right.
It is what it is. Well, ladies, I think this has been at least a great introductory conversation on this topic. I suspect we're not done with it yet.
Stay tuned.
Stay tuned.
Stay tuned.
Yeah, I suspect there's going to be a few more. But anyway, thank you, Susan and Trisha. This was a great chat today. And thank you for joining us on this episode of 3Bs on the Law. Thank you for joining us on today's podcast of 3Bs on the Law. Don't forget to like and subscribe to our podcast. We also welcome any comments. If you'd like to get in touch with us or suggest a future topic, you can email us at 3THREEBsonthelaw@gmail.com. And because we're lawyers, we need to remind you that this podcast is not meant to provide you with legal advice and does not create an attorney-client relationship. Thank you again for joining us, and have a great day.